time for you folks, and I'll explain that in a moment. This is the time set for oral argument in 1CA-CD 20-0363 Gonzalez v. United Financial. We're in the virtual world, and based on our current protocol, you folks will be arguing from where you're at. You do have a maximum of 20 minutes per side. I'll remind you that you are not obligated to use all that time. We do require you to keep track of your own time. We don't have clocks on a podium, and we can't put clocks on the screen because the only clock we can put on the screen would literally take up the whole screen. So we're not going to do that to anybody. I will also be keeping track of time, and we'll try and give you some signposts along the way as to how much time you have remaining. If you want to reserve any time for rebuttal, you will have to do so on your own. When you do finish speaking, I will tell you how much time you have remaining for rebuttal. If you have a question about where you're at as far as time at any point, please let me know, and I'll give you where you're at. Please keep in mind that we have read all the briefing, we have studied the record, and we have discussed the case in detail in conference. So with that, Mr. Abney, you may proceed.
Let's see. Yeah, got the mic on. Okay, thank you, Your Honor. May it please the court. My name is David Abney, representing Stephanie Gonzalez. I think I can probably keep my remarks fairly brief today. The main point I'd like to make is that this case falls within Manning, and in fact is even stronger than Manning. The passenger in Manning was 2 or 3 feet standing behind the car. She was waiting to take part in the process of putting on the snow chains, but she wasn't doing anything at the time. She was just standing there and had been standing there for about a minute when she got struck unexpectedly by the other car. Now, in our case, we've got a much more direct engagement with what's going on. Stephanie had gone to the Uber car. She had talked with the Uber driver. She had opened the back door and closed it. I don't know if she got in or not. I suspect probably not, but it's really a little bit up in the air. The Uber driver said that she didn't think that she had, but couldn't really definitively say one way or the other. And then as she's backing away from the car, she's in the process of trying to get all the members of her party together so they can leave in the Uber car. She's maintaining eye contact with the driver, wants to make sure she keeps that connection. So far more than the passenger in Manning, Stephanie is maintaining her participation in the car. She's maintaining contact. She's close to the car. She's participating in this overall process of entering the car as she's trying to get the other people together with her. So much more than in Manning, she is actually in a sense entering the car. Now, what struck me about Manning?
Counsel, you say that she's entering the car, but the facts show that to the extent that she entered the car at any point, she was not entering the car at that point. She closed the door and was in fact backing away, not moving towards the car. How is that entering a vehicle?
Well, she's not literally physically getting into the vehicle, any more than Deanna Manning was physically upon the vehicle in that case. What she's in the process of entering the vehicle, she has made the contact with the driver, spoken with the driver, maintaining eye contact with the driver, moving slightly back as she's assembling the people that are going to come with her to enter the vehicle. She's in a process of entering the vehicle.
So if her friends were in a restaurant 3 blocks away, was she entering the vehicle the whole time as she's going to gather her friends? Because that's the fact you're relying on. She has to gather.
Right. If she went 3 blocks away, no. One of the things that's important in the Manning case is that she's the person there was in close proximity to the vehicle. We're not quite sure how close Stephanie is, but she is reasonably close to that vehicle. She hasn't gone 3 blocks away to a restaurant. She is so close that she's maintaining the eye contact with the driver, maintaining that sort of communication link with her, one to make sure that the driver's there, stays there while she gets the other people into her party.
Well, that's interaction with the driver, but that's not interaction with the vehicle at that point.
Well, it's really the same thing. It's the vehicle that's her focus. Everything that's going on, the nexus of her activities is that vehicle. much more so than Deanna Manning, who's really just standing there waiting and not doing anything at all. Stephanie is doing things. She's trying to maintain that connection with that car while she's getting other people together. So she has a much closer connection to what's going on with the vehicle than in the Manning case, and that was sufficient. And as I said, literally, Deanna Manning was not upon the car. She was 2 or 3 feet back from the car.
You're using, well, the court actually said that she was upon the car in Manning, but here we don't have the language of upon.
No,
We have
we
much
don't.
narrower language. We have in, entering, or exiting. No
Well,
upon.
the court in Manning said that there is a line of cases that actually requires physical contact. And so Deanna was not in physical contact with the car. She was not literally sitting on it or crouching on it or standing on it. She wasn't doing any of those things. She was distant from the car, 2 or 3 feet, and not doing anything else other than waiting to take part in the process. And here we don't have Stephanie waiting to take part in the process of getting herself and her friends into the car. She's actively participating in that process. She's a central figure in it. She didn't call, interesting enough, she didn't call the Uber driver, but you know how these group interactions go. She's the one that took the lead to make sure that she got in the car and everybody else entered the car as well. So
So
there's a much,
let's say it was a little different. She's on the other side of the street and she jaywalks and gets hit by a car. Is she entering the car there?
I don't know what she's doing. If she's jaywalking to get to the car and she's reasonably close, perhaps that would satisfy the standard. But here we actually know
Well,
she actually
but she's at
went
least
to the car.
in what I just gave you, headed towards the car. Isn't she really in the act of gathering her friends? And then the next step is entering the car. But what she's doing is walking away from the car to gather friends.
Well, it's still part of the process of entering the car. She can't definitively enter the car, at least the way she's doing things, until she has her friends with her. It looks like she contemplated getting in the car. She goes to the car, she opens the back door, she closes the back door, and then decided to back up a little bit and see about assembling her friends. But there's different ways to get people together to get them in a car, and that's the way she chose. And the defense
And
faults
she
her for
chose
that.
to do so by not entering the car, did she?
Well, yes, and the defense faults her for that. But that's really a question of contributory negligence. Should she have gotten in the car to do the call? And they'll say to the jury, well, she should have done that. None of this would have happened. And then it's up to the jury to decide the comparative fault.
We're here on a coverage issue, not negligence.
Right. And
So it's
that's why whether she's in the car, physically in the car, as opposed to being in close proximity to the car and having this nexus with the car and connection with the car, it really, under Manning, it doesn't matter. What matters is what she's doing integral to her operation and use of the car in the sense of entering it. And it is. It's all part of her getting into the car, getting her friends in the car, and then leaving. Her focus is on that car. As part of that, of course, she's maintaining contact with the car driver. I mean, it wouldn't make any sense just to stare at an empty car. She wants to maintain the contact with a person who's actually going to be doing the driving. So I think we fit within Manning, and all the other cases that we discussed in the brief, and I won't go over those because there's way too many of them. But if you distill them down, there's certain things that are going on. You're being in close proximity to the vehicle, although sometimes close proximity in those cases is a long ways away, and actively focused on that vehicle. The vehicle is integral to your use. And when you add all these things together, you get occupancy. Now, whether it's upon the car, and of course, literally in Manning, she was never upon the car. She was in the car. She exited the car, entered the car. She was playing with her camera. But when this all happened, she was simply standing behind the car. So I submit to the court.
Mr. Abney, let me jump in for a second. This Judge Brown. So it seems like you're suggesting on a plain language analysis that Manning was not correctly decided. I mean, if you're looking, let's just look strictly at the dictionary definition of upon. I mean, or, what does that word mean to the average person walking up and down the street? Miss Manning was not upon the car, as you suggested. She wasn't upon it because she wasn't touching it. So was Manning correctly decided?
Well, yeah, and this court in Manning said there are cases that require this actually be physically on that car, physically touching the car. We're not going to go that way, because what you're buying what you're getting when you have insurance is an expectation under the Motorist Responsibility Act and under the general nebulous terms of the policy, an expectation of coverage when you're close to that car and when you're using that car, and the focus of everything you're doing is on that car. And that's what was going on in Manning. I mean, they considered, well, should we be literalists about this? Or should we look at this in the broader sense of what is it that you're actually getting when you're getting coverage for occupying the vehicle? And what you're getting is coverage that when you're in the close proximity, you're using that vehicle, and an expectation that you're going to be doing things with that vehicle. When that nexus is there, you've got the coverage. So they considered this literalist approach and said, no, that's not the way we're going to do it. And I submit to the court, that's not the way you should do it here as well. She is in the process. Entering a vehicle is not as simple as opening a door, sliding in, closing the door. There's a lot more that goes on to it, especially if you're not alone and you're trying to get a group of people together and make sure that they get into the car with you. So I submit that Manning was correctly decided. I have no problem with Manning. And I'm glad that they didn't choose this literalist approach. It's really a little silly. Upon the vehicle, what does it mean upon the vehicle? Put your hand on the vehicle. Are you upon the vehicle there? You actually have to be sitting on top of the vehicle or in the vehicle. I mean, upon the vehicle, I get this image of somebody sitting on the roof, like an Animal House. And, that's not, I don't think that's what occupying was ever supposed to mean.
And so that you have 10 minutes, counsel.
Well, actually, I'd be happy to reserve my time, and I won't use all the 10 minutes if I may do that, unless there's other questions. All right. Thank you, Your Honor.
I'm not seeing any. So you have 9 minutes and 50 seconds. Counsel, Mr. And I'm sorry, I'm going to forget how to pronounce your name. We can't see you right now, so if you could make sure you turn your camera on.
And I'm sorry, Mr. Richards is here. I obviously had some problem connecting. My camera shows it is on.
I can see you now.
Okay. Sometimes I know the camera moves to the speaker. I saw Mr. Abney when he was speaking.
Okay. I don't know. I thought we had both attorneys when we started. So if that was not the case, counsel, I apologize.
No, that was not the case. I was apparently on the wrong link and waiting in the waiting room. And I did get an email from Lena saying the hearing had started. I clicked on that link, so I did join. But I just heard the very end of Mr. Abney, probably 3 or 4 minutes.
I'm not going to start over, but counsel, I'll go ahead and hear from you. If you need a little bit of a follow-up after Mr. Abney gives his rebuttal, we'll deal with it that way, if that's okay.
Sure. And Mr. Abney's comments may have provoked some questions, and I'd be happy to answer those as well. That may be a way of framing his argument. I did hear him talk about we can't literally take a word like upon. And of course, the biggest problem in this case is the insuring clause does not include the word upon. It includes in, entering, or exiting. So this case is distinguishable from Manning in several respects. And in fact, the trial court made reference to the ways in which this case is different from Manning. In Manning, the person de-manning was stationary behind the vehicle 2 or 3 feet. In this case, Ms. Gonzalez was moving away from the McCabe vehicle. Unlike Manning, Gonzalez had not occupied the McCabe vehicle. Remember that Manning and her companion had traveled from Colorado, and it was a little bit different setup because the people had been occupants of the same vehicle for a period of time. We think the question in this case is when we talk about literally, we have to read the language of the insurance policy because that's what controls coverage. and the coverage clause does not include the word upon. So while those various cases citing by both parties illustrate some points for the court, they aren't controlling. Manning, we find, is very important to this case. And by the way, I'm getting some feedback. I don't know if the court is as well.
We are not at this point.
Okay. If you have trouble understanding me, I'll try to make it through the feedback on this end. The Manning court actually found in that case that Ms. Manning was not in, entering, or alighting from the vehicle. It was the inclusion of the word upon in the insurance clause which allowed the court to interpret all the myriad of cases which go back and forth, and the courts have commented can be quite confusing and contradictory with each other. There's a couple ways to look at this case, and I think the court correctly.
Let me ask, what do we do with some of the cases that do have some level of proximity, though no physical contact with the vehicle, that also don't have the upon language?
Well, the question is whether upon opens up the proximity issue, and I would say it does. I think we know what being in a vehicle does or is, and I think we know what entering and alighting from. They're common words. They don't raise the same issues, getting into subjective issues that come from the word upon.
Let me ask you, if we change this, and this is similar to what I asked Mr. Abney, what if she was actually headed towards the car when she was hit? In other words, may not have gotten same place on the street, exact same place, but her trajectory was different. She's now not backing away, having closed the door. She's now headed towards, with certainly the assumption to open the door and get in.
I think that question is directly answered by our opening brief, which is index of the record 19. On page 7, we cite a footnote there to a Minnesota case of Gelstad versus State Farm. And the case identifies the danger of placing too much emphasis on a person's intent. And it goes on to say, keying in too greatly to an injured party's intent would send courts down a dangerous, slippery slope. Indeed, doing so might mean, for example, that a person walking toward her vehicle was occupying it simply because she intended to enter upon reaching it. Accepting that premise would stretch the term occupying beyond its commonly understood meaning.
So what if she was right there and her hand was just inches from the handle when the car hit her? Would that be close enough? Is that what we're talking about? Or does she actually have to put her hand on the car?
I think in that case, without the word upon, I think she has to touch the car, touch the handle. By touching the handle, she's beginning the entering process. Here's the way I've looked at this case. She opened the back door. She started the entering process. She closed the back door. I believe she reversed that process at that time. Consistent with that, she described to the driver, I'm going to go get my friends, wait here, held her hand out, and then began walking away from the vehicle, consistent with the theory she was not entering it. I would say that she started to enter the vehicle and had exited the vehicle by her further conduct. The trial court looked at a small variation of that. The trial court said she put her entering activities on hold when she took the action she did. The problem is if her future intent of what she intends to do controls, there's problems on both ends of the analysis. First of all, gathering her companions even before the rideshare driver arises, if gathering the companions is considered an act of entering, coverage starts as soon as they leave the bar and they're walking together and they're gathering each other up. if any of them are hurt, although the rideshare driver may not be in the area at that particular time. But under the Gonzalez theory, there would be coverage because gathering co-passengers up is an act necessary in a necessary relationship with the vehicle and things like that. The other is, if we take the facts of this case.
Let me ask you kind of a different question, but
Sure.
related, because you talk about gathering friends. What if, oh, never mind. I think I'm gonna, I don't know that it would work with a coverage question. I'm gonna.
Okay.
Not interested.
On the other end, if we look at what she was actually doing here, does the coverage ever end? We know her intent to get in that vehicle never ends. That's the vehicle she intends to go to Ms. Hallett's apartment in, as is true for the other people. She's walking away from the vehicle and she's about in the middle of the street, right near the dividing line between the two lanes, and she's struck. What if that didn't happen? What if she continues walking all the way to the north curb? What if something happens at the curb? What if she's frightened by something and falls down? She's gathering up her friends under the Gonzalez theory. Perhaps she has coverage for that as well. What if to find her friends, she had to walk around on LaRue, the street running north-south near the accident, and had to find her friends over there? Would there still be coverage if something happened there? We believe.
So I guess, Mr. Richards, is what
Yes.
we're looking at is, we're not going to define where that line is, but what we can say is this isn't that line. Is that what you're arguing?
I think that's absolutely true. I think, I know that the Gonzalez theory is she was entering the vehicle. I've kind of analyzed the case as she started to enter, but then she had exited. If we look at it as entering, the Manning case directly holds Ms. Manning was not entering that vehicle. You can affirm Manning. Manning, I would agree, is rightly corrected. It gets into the morass of the upon cases, which isn't necessary here. But all you have to find is consistent with Manning, she was not entering the vehicle. Consistent with Manning, the word upon is not in the insuring language here. It's not necessary to get into those cases. And all the subjective factors raised by the presence of the word upon in the insurance clause, we really don't have to look at them in the detail we otherwise would if upon were the issue. But remember,
so you know.
Pardon me?
10.5 minutes left.
Okay. And the trial court, well, and I lost that train of thought, so I'll move on. And actually, I can stop there and reserve my time since the court has graciously given me that opportunity.
All right. Well, you ended right at 9:50, which is where Mr. Abney stopped. So, Mr. Abney, and I'll again give you that opportunity to reserve some of this time for rebuttal, because we seem to have taken a slight misstep with Mr. Richards. But whenever you're ready.
Thank you, Your Honor. I feel like I'm in a parliamentary debate. My colleague across the aisle said that opening the door started the entering process. I would say it actually started earlier when she made contact with the Uber driver, spoke with the Uber driver. But even if you take it as opening the door, starting the entering process, it didn't really go on hold, because as the Manning case said, at the time of the accident, the appellant was waiting to perform specific physical assistance, but the record does not suggest any inconsistent activity or abandonment of purpose. And here there was never any abandonment of purpose. There was never any inconsistent activity. From the time of her first contact with the Uber driver, Stephanie was in the process of entering that car herself and getting other people to enter the car with her. My colleague across the aisle also said that the intent to get in the vehicle never ended. and it did never end. But the intent is only a part of what the court was looking at in Manning, the purpose, the uninterrupted purpose in Manning of Deanna Manning to help out with the snow chains whenever it became her time to do that. But what's
counsel isn't turning her, well, she didn't turn around, but backing away when her purpose changed. Her purpose changed to gathering her friends, not getting in the car, didn't it? If we're going to use that.
No, I don't think her purpose changed at all. I think she revised how she was going to do this. It appears to me if you're going to go up to a car, you open and shut the door, you're thinking about getting in, and you're thinking about getting in. In her case, to get contact with her friends by phone. That's probably what she had in her mind. And then, as far as we can tell, and reasonable jurors could have to figure this out, she decided, well, maybe it'd be better to stand up, back up a little bit, keep contact with that car, maintain that communication with the driver, and see if my friends are around so I can get them over here. You know, either way is a way to do it.
I guess my concern, counsel, and I you took me back to Family Circus. We all have seen Family Circus, I think.
Mm-hmm.
And mom looks out the door and says, PJ, come in. And then that whole scene is just PJ doing a million different things and finally getting to the door. Isn't that what this is? She was, that may have been her goal, but she took a couple of detours that canceled coverage.
Well, first of all, I enjoy Family Circus, and I love the episodes where the kids are doing 1,000 things before they actually get to where they're supposed to be. But she's not doing that. She's maintaining her very close communication, direct communication, and is just a few feet away from that car throughout this entire episode. She has not abandoned her purpose or changed her purpose within the sense of Manning. She is part of this process of entering the vehicle. You know, the thing about Manning is it's not a literal approach to the policy language. It's looking at the purpose of the coverage, which is to provide you coverage when you are, as Manning said, actively participating, continuing, what did it say? Close proximity, what you're doing is related to use and an integral part of your occupancy and use of the vehicle. And what she was doing was all of those things. So I think we fit within Manning. And it's not, as Judge Brown helped me to point out, it's not a literal approach to things at all. It's taking a broader view. And I'll reserve a few minutes if I need it, but you know, if I may.
Brad, did you have a question? I couldn't tell.
Sorry, I was just going to ask you real quick. What about you mentioned how this is approached in Manning, but what about Tufel? The Tufel versus the Supreme Court case, Tufel. And I think that the Supreme Court made it very clear that we, sort of like statutory construction, we start and end with the policy unless there's ambiguity there. So, I mean, what are we to do then? Because Manning didn't do that. Do you agree with me on that? Manning did not do a sort of a plain language. They did, as you mentioned earlier, they sort of cast that aside.
Well, they weren't literal, but the difficulty is, I think we all have sort of an image of what a pawn means, although I'm not quite sure how it fits with a car. A truck, I can understand a pawn a lot better with a truck, but the point of the language here is this entering is a nebulous word. It's vague. What do you mean with entering? When my colleague says, across the aisle says, if you open the door, you started the entering process. Well, you're not actually entering the vehicle. You're not getting into it. You're simply opening a door. Entering is a broad thing, and she is in the process of entering this from the moment that she contacts that Uber driver, physically talks to the Uber driver, goes over the car, opens the door, shuts the door, talks with her some more, backs away a little bit. That's all the process of entering the vehicle. And I submit that if you're gonna make this coverage have some meaning and actually protect people, that you should give a broad interpretation to entering, just as the court in Manning gave a broad interpretation to a pawn.
Thank you.
Thank
you, Your Honor.
You have 4 minutes and 15 seconds left.
Thank you, Your Honor. Appreciate it.
New parliamentarian approach to oral argument. A little more Superior Court-like, I think.
Yes, sir.
For a rebuttal. So I apologize, but I did want to give Mr. Richards a fair opportunity. So, Mr. Richards, you have 9:50.
Thank you. And I doubt that.
That time if you don't want.
The big difference that we've said throughout the pleadings, we emphasize with the lower court and really have to emphasize again. In Manning, the court looked at the cases that decided the issue of upon, and it said there was ambiguity in those cases, and it pointed specifically to the contact issue. It said some cases wouldn't find you upon if you're would not find you upon unless you're touching the vehicle. Other cases don't require touching. The court said specifically we don't require touching. But it recognized the variation in the cases around the country. And indeed, based on the word upon, a lot of courts have come up with subjective type tests where the whole kitchen sink literally comes in and you just consider every factor in the case. And ultimately, the decision is for the judges, do you want to provide coverage or not? And this court can find inconsistent opinions where under the very same facts, the courts of the different states would reach different provisions. And I'm hearkening back to Judge Brown's question because I absolutely agree. This case starts and it ends with the contract language. And if there is no ambiguity, we don't have to come up with a lot of fancy arguments. All we have to do is interpret the language. In this particular insuring clause, while we have no testimony from an underwriter as to why exactly the word upon was taken out, but in light of the confusion, it appears pretty obvious that the insurance company was troubled by that word and didn't like the back and forth where coverage could be different in different states, depending upon the court decisions in that state and whether the court applied a test of whether it's vehicle oriented or pedestrian oriented or some other subjective test based on the totality of the circumstances, as some courts did. This policy is written simply. It doesn't get to the Manning test. The Manning test was, are the person's activities so related to the operation and use that they're an integral part of one's occupancy and use of the car? Now, I would contend in Manning the actions were much more directed to the car than they were here. And I would contend it's a completely different task to cross the street and go get your co-passengers, and that she was engaged in that activity at the time. At the time of Ms. Manning's accident, she was waiting for Joey Santa Maria to position the chains under the tire. That's a one-person job. Her job, and the reason she was standing there, is once he had them positioned, they had to be attached. And that was a two-person job in which she was going to engage. And she could have been called upon at any moment to engage in that vehicle-oriented task. And based on those sets of facts, the court said there's coverage utilizing the word upon. Again, we can throw out the whole analysis because upon doesn't exist in this case. But even if the court were to say, well, Manning controls, and let's just look at the Manning language and let's try to apply its test, I still believe the test would not apply because Ms. Gonzalez had changed her position. Rather than entering the vehicle, she decided to recross the street, go find her friends, obviously with the intent to re-enter the vehicle, but engaged in a different activity. And we've cited cases in the pleadings to you, among them the Giannis case from Florida, in which the court has just said flatly, crossing the street is a different activity. When you're walking away from the car and you're crossing a street, that's a completely different activity. To that, we could add the fact that Ms. Gonzalez was taking that path with a different purpose, that purpose being to find her friends. And by the way, we had no idea how long this task was going to take. We don't know exactly where those friends were. We know that Vanesha Flanagan and Nyalisha, who had been talking to the high school friend of Vanesha, that they were still together. There were two other people on the other side of the street. We weren't sure if they were still in one group or not.
Well, and so that from my understanding of the record, neither was she. She did not know where they were at. In fact, she thought they were right behind her. So in that regard, it's not so important that we don't know, but the fact that at that moment, as she started to back across the street, she didn't know, did she?
And you're absolutely right, and that's much more eloquently said than I did. She was really crossing the street to go to unknown locations for an unknown duration of time. Much unlike Manning, who was standing behind the car to perform a task of attaching the chains, which had both a beginning and an end to it. But she was there for that vehicle-related purpose. And
you have about 4 minutes left.
Okay. Judge, I think I've made the points I have. Unless there's any questions, I'm prepared to turn my time back in.
All right. Mr. Abney, give me just a moment. All right, go ahead. You have 4 minutes and 15 seconds.
Just a couple short points. One is that entering a vehicle is at a minimum of two-person process, although here it may have involved more. You need to get people safely and efficiently into a car. You need communication with the driver. You don't want the driver taking off on you, for instance. And you need a person to actually enter the vehicle. So it is a two-person process, much like putting on chains. There's been sort of an inclination to state broadly, well, she's crossing the street. What she was doing was backing up slightly. We don't know how far she backed, how many feet away she was, but whatever she was doing, she was maintaining eye contact with the car driver. If she was going to be crossing the street, you would think she'd look around at least and not be maintaining continuous contact with the car driver. She was focused on that. And I suspect trying to be visible for her friends to see her, but we won't know that. And that's going to be something for the jury to ponder. I think we fit pretty closely within Manning. I could read Manning out loud to you for a while, but I think that would waste the court's time. What matters is that you're in close proximity to the car. You are focused on that car. What you're going to be doing has to do with that car. And the word occupying in this sense would cover the entering process that Stephanie Gonzalez was involved in when she was struck. And with that, unless there's further comments, I would cede my remaining time to the court. All
right, and thank you, folks. And I can assure you, reading Manning out loud would probably not have been a good idea. We have read it to ourselves quietly. So yes, I appreciate you're not doing that.
Yes, sir.
Thank you, counsel. Apologize for the little glitch, but I think with our new format for appellate argument now, which I suspect we will not adopt as a regular process, I appreciate your time. We'll take the case under advisement and we'll assure ruling in due course.
All right, I'll be back for the next case, so I'll see you then.
All right, and so now you will be going to a different link. So
yes, sir.
We'll close out of this completely. That's where I think we had a glitch with Mr. Richards.
Okay, I will do that. Thank you, Your Honor.